Hi friends, this is CMA Deepika Bugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, an illuminating snippet series curated by me. I invite you to join me as we delve into pivotal judgments under the Insolvency and Bankruptcy Code to navigate the complexities of insolvency proceedings and the key judgments having an impact on the IBC Code. So today I will discuss with you one such judgment. So today we will discuss the case of Hari Babu Thota, RP of Shri Ashray Infracon Limited, Supreme Court. So what is the factual background of the case? On 29th of November 2023, a division bench of the Supreme Court of India in Hari Babu Thota adjudicated on the exception from Section 29A provided under Section 240A of the IBC Code for micro, small and medium enterprises. The Honorable SC here dealt with certain pertinent questions, viz. Whether a corporate debtor who obtains an MSME certificate post the commencement of the CIRP would be eligible for the same exemption, and whether all promoters are restricted from being resolution applicants under Section 29A of the Code. The present appeal arose from an order dated 2nd of June 2023 of the National Company Law Appellate Tribunal, Delhi, which dismissed the resolution plan filed by the resolution professional. The grounds for such dismissal was that the promoters are prohibited from presenting a plan under the bounds of law once CIRP commences. Alongside, the Honorable Supreme Court has also interpreted the language of the code to allow the resolution applicant to file the MSME certificate at the time of submission of the resolution plan, disagreeing with the NCLAT New Delhi in Digambar Anand Rao Pingal versus Shrikant Madanlal Zawar and others. Now, what were the issues before the court? One, that whether the resolution applicant, that is the promoter, was disqualified under the primary conditions of Section 29A of the IBC, and whether the corporate debtor not having an MSME status at the time of commencement of CIRP proceedings would disqualify as the RA under Section 29A of IBC, and the benefit provisioned under Section 240A of IBC would not apply. Now let us see what are the views of Honorable SC on Section 29A of IBC. The Honorable Supreme Court analyzed Section 29A clauses C, G, and H of IBC and said that it was inserted to the IBC Wide Amendment Act 8 of 2018 with effect from 23rd of November 2017. The said provision was introduced to curb the attempts by the resistant promoters of insolvent companies to regain their control over the company, leaving the creditors with a massive haircut. The intention of the provision is to restrict the persons to submit a resolution plan who may have an adverse effect on the CIRP. The Honorable SC analyzed relevant clauses of Section 29A of the IBC. Clause C discusses a lapse of 1 year from the date of classification as an NPA. The Honorable SC noted that in the instant matter, there were no bank dues to attract NPA. Regarding Clause G, the division bench acknowledged that one preferential transaction was identified by the RP, but no order was passed by the adjudicating authority. The Honorable Supreme Court further stated that Clause H had no factual application. The SC clarified that the above-mentioned clauses are specific to the promoters, and as per the said clauses, the company's promoter is not disqualified to present the resolution plan. Now let's see what was the Honorable Supreme Court's view on Section 240A of IBC. The SC analyzed the decision of the NCLAT in Digambar Anand Rao Pingal, wherein the application for MSME certificate was made after the commencement of CIRP, and it was stressed that such unauthorized application could not evade the ineligibility under Section 29A of IBC. Hence, Section 240A of IBC would not attract in such cases. While analyzing the scope of Section 240A of IBC, that was inserted Wide Amendment in 2018 with effect from 6th of June 2018, the SC clarified that clauses C and H of Section 29A apply to the promoters and exempt them from presenting a resolution plan. However, the same does not apply to MSMEs due to the nature of business it carries. The Honorable SC further stated that under the heading exemption of micro, small, and medium enterprises from Section 29A, the discussion begins. It is referred to the Insolvency Law Committee report of March 2018 and its finding that micro, small, and medium enterprises form the foundation of the economy and are key drivers of employment, production, economic growth, entrepreneurship, and financial inclusion. The ILC report 2018 exempted these industries from Section 29A, C, and H. Further, it opined that excluding such industries from disqualification under 29A, C, and H is because qua such industries, other resolution applicants may not be forthcoming, which thus would inevitably lead not to resolution but to liquidation. The Honorable SC stressed on the point that challenge to Section 29A of the IBC was repelled in the case of Digambar Anandrao Pingle while moving the amendment bill, giving the object of interpretation of Section 29A and referring to the disqualification clause under Section 29A(c) of the IBC, which applied on the corporate debtors and provided the cutoff as the date of application for making the bid. What was the decision of Honorable Supreme Court? The Honorable Supreme Court concluded that while interpreting Section 240A, the reason for carving out an exception in MSME industries is set out on the date of application for making the bid as the crucial date. It further added that while for some other aspects, the initiation of the CIRP proceedings would be the cutoff date, the same would not apply in the case of Section 240A, in view of the statement by the minister themselves while introducing the amendment bill. The SC, agreeing to the notwithstanding clause, stated that while seeking to protect MSMEs, the disqualification to promoters would not be attracted. The court stated that the date of initiation of CIRP proceedings being the relevant date was an incorrect legal view. It added that the law laid down in Digambar Anandrao Pingle by NCLAT is inconsistent with law and that the date of submission of resolution plan must be the cutoff date. The Honorable Supreme Court concluded that the resolution plan submitted in the instant case does not incur disqualification, and the orders of the NCLT and NCLAT were set aside by the Honorable SC while allowing the present appeal. So, dear friends, we see that the intent of the law was gauged at the time when the amendment was introduced, and the Honorable Supreme Court has once again protected the MSME industries and has laid out that the MSME industries certificate would be valid as on the date of application for the resolution plan. So thank you all for being here today. And once again, this is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.